David asks, what difference does having an attorney make in a criminal defense case? Why should you get an attorney? Does that mean you pay less fines or potentially serve less time?
I mean, it can mean it's a world's difference. You know, in the municipal courts here in St. Louis County and in St. Louis City, you're not going to get a public defender, you know, to defend you in an ordinance violation or what's the equivalent of like a misdemeanor. It's a world difference. People who don't have a lawyer, they're typically going to go to court several times. It's going to take hours of their time, and if they do finally get to the point where they're sitting down with the prosecutor discussing the case, they're not going to know what to ask for. They're not going to know what to do, and they're going to leave there. If the case does get resolved, eventually they're going to leave there not having any idea if this was a fair deal or how it kind of worked out. When I have clients who have defended themselves in court before, they'll tell me that I didn't get convicted, and I'll look it up and I'll say, hey, you know, sorry to tell you this, but you did. You know, it's just important to have a voice. Not having a lawyer is dangerous, especially when it involves a criminal case. When you have a felony case, you're going to go to court several times without a lawyer, and the judge is just going to keep asking you. Most people who have public defenders, they're locked up in the jail. They're the people, it's proven that they need it. If they had a bunch of money, they would have posted bail. So generally speaking, it's a world's difference. Who knows what you could end up agreeing to? I have a client who has a felony stalking in St. Charles County involving an ex-girlfriend. He doesn't have any priors, okay? The offer, he did not have a public defender. He was going to court on his own. The prosecutor offered him an SES for a first-time felony, so he would be a convicted felon with 5 years, full 5 years probation. The SES with a backup. I don't remember how many years it was, but I think it was the maximum they could sentence him to in the backup. And anger management classes, domestic violence classes, even though it wasn't a violent case. And he could have accepted that. You know, they were putting pressure on him to accept it. If they did that, he would have a conviction of a felony on his record. He would have miserable probation terms to get through. And when you get a lawyer involved,
people need to remember that and I don't want to cut you off, but you know, listening to you say that, it's kind of like me in the civil, like in the PI case, because I say, you know, this ain't my first rodeo. I know how to do this, and because the criminal law and criminal charges, as well as on the civil side, it's an adversarial system. That prosecutor is not looking out for the person charged. They're there to get as much of to do as well as they can against them. So people who go into court, you know, people do that in housing court and others, but if you go into court by yourself thinking that the attorney on the other side is going to do you a favor, going to be straight as shooter with you or act in good faith with you, it's just not going to happen. Because there's nothing wrong with them. They're doing their job. They are sworn to get the best deal that they can. Just like Eric, you're sworn to do the best by your client. It's just the way it works.
Well, it's like that in personal injury, Gary. Like you get in a big car accident, you go to the hospital once. You haven't hired a lawyer yet. What's that adjuster going to do? They're going to get to you early on before you get any additional treatment that you may need. And they're going to say, hey, you don't have to split this money with an attorney. Take this $1,500. You don't have to share it with a lawyer. You know, we'll pay the hospital bill. It's tempting for people who don't know better. And the thing is, you know, I guess my thing is the difference between a prosecuting attorney and an adjuster in that situation, they just resolved a claim that could have been worth several thousand more than what they sell it for. I don't know if there's actually like financial compensation for that, but they're certainly doing, it's awful what they do to people, but they're doing a good job at what they're doing. I don't know. I think the prosecutor, they need to use a little more discretion.
Can a person? I am following up with another. I hear you. I following up with another question from David. Can the person go up and negotiate with the judge on their own without a lawyer?
So yes and no. I mean, the judge cannot amend a charge. So let's say you get charged with possession of marijuana, and the reputation around St. Louis County is you might be able to get it bumped down to littering. A judge can't do that. The only person who can amend a charge is a prosecutor. So the only thing there is to negotiate with a judge is after you plead guilty. and what the result is. A judge can give you an SIS, but a judge cannot take a charge and make it something else. So the negotiation, sure, you can negotiate some probation, maybe you get a great deal, but most of the negotiating, like a misdemeanor happens with a prosecuting attorney, they have the authority to do a lot more for you if they're so inclined.